Oyez, oyez, oyez. Anyone having business before the King's Justice of the Superior Court of Justice, attend now and you shall be heard. The Honorable Madam Justice Hennessy presiding. Long live the King. You may be seated. Unless done in accordance with the Superior Court of Justice protocol on the use of electronic devices, these proceedings are not to be recorded. Thank you.
Good morning, all. Good morning, sir.
Good morning, Your Honor.
Oh, we've got it. Yep. Great. Okay. So as for those who don't normally have the privilege and pleasure of experiencing in Northern Ontario winter, you are very lucky today to see it in its full flight. Okay. You're ready to go, sir.
I am. There's a binder that should have made its way to you.
Thank you.
Is making its way to you. Morning, Professor Stiglitz.
Good morning.
My name is Len Marcello. I represent the province of Ontario. I look at your new opening report of January the 24th, and I see that you and Professor Hutchings were requested by council to calculate the value of the Superior Treaty Territory lands, waters, and resources that were extracted and or used from 1850 to 2019, correct?
That's right.
And you do this through the medium of what you call economic rents in the territory rather than through net crown resource revenues, correct?
That's right.
And basically your proposition is that the Crown didn't capture sufficient rents in respective resources that were actually exploited from the territory. Is that the long and short of it?
No,
Okay. You say that there were uncaptured rents.
yes.
Okay. So clarify that for me.
Well, the point of the value calculation was to explain, as I put it, what the Onashepa brought to the table. What was the value of the resources they brought to the table?
Right.
That's all that's about. And because of the lack of availability of data, we wind up with a conservative estimate of
Yes.
the value of what they brought to the table.
Yes.
Just a very simple question.
Yeah, I heard that point made several times. The delta, though, is that you see a difference. You see daylight between economic rents in relation to the resources exploited and what was turned into actual Crown revenues.
That's right. And there were,
That's what I'm getting.
yes, there was a difference between the value of the resources and the value that was captured directly.
Right.
And then there was another value that was captured indirectly.
Which you put at 25 to 35%, if memory serves me.
That's right.
Okay.
Mr. Marcello, just before you go on,
Yes.
can I ask council to look at 10:08:46? Was the answer yes or no? Just before you asked, Mr. Marcello, just before you asked the question, so can you clarify that for me?
Yep.
Is the answer you had received no?
I don't remember what the question was at this point. I gotta look at it.
The question, your question, Mr. Marcello, was you say there were uncaptured rents.
Right. I think that's what the professors come around to actually are agreeing with. There was a difference between the economic rents that could have been turned into resource revenues and the ones that actually were turned into resource revenues, right?
That's right.
Okay.
So like, for example, you know, companies like Abitibi Paper or whatever, you would say, to bring this down to earth, the Crown chose to charge a stumpage fee of say X, but it might have charged a stumpage fee of X plus something,
That's right.
just to give a mundane example. Okay. Now, the first document in the binder, I'm not going to mark this, Your Honor, unless you want to, because it will be marked, I think, without dispute when Mr. Hutchings comes to give evidence next week. This is an excerpt from his report. It's at tab 1 in the binder. it's a reference to paragraph 14J in his main report that goes back to January of 2022.
Mr. Schachter's on his feet.
It would make sense if you'd like to mark it all as exhibit F or F.
If you want to mark
As
this
for
excerpt,
edit.
you mean? Mark
No, the
yes.
whole thing.
Your compendium,
Yeah, mark your compendium as
Sure, we
exhibit
can-
and
F.
then it's in.
We can mark the compendium.
Does that help? And then we'll do it.
However,
Exhibit and tab 1.
Some
No,
of what I'm
that's
referring
exactly-
to, most of what I'm going to refer to is already marked, like exhibits 3 and 4 and certain things that have tabs in the JBD. So there are very few stray documents. This happens to be one of them. If you want to mark the whole binder, we can do that.
Any,
What's that, 6 or? I can't remember.
was that your preference, Mr. Schachter? I'm just,
So we're dealing with the lettered exhibit?
Well, this should be a numbered exhibit, I think. I mean, it's.
Well, it'll
it's
eventually
not-
be a numbered exhibit. when
Yeah.
it's entered as part of Mr.
Yeah.
Hutchings'
Well-
report. I don't know. If it's a copy of what Mr. Hutchings' report is,
It is.
and he wants to simply mark it as a separate numbered exhibit, that's fine. I don't have any objection. I think it's a waste of a number, but that's.
Can we
I
spare a
don't have
number,
any
Your Honor?
objection.
numbers are always precious.
It's not a letter, so.
Um,
I don't want to interfere, but there's no scarcity value.
Yeah.
What
All right.
number are we at, Madam Register?
I'm
This would
guessing
be 6.
6.
No,
Alright.
just the one.
All right, so tab 1 is exhibit 6. So here, to finally get to the point, the Mr. Hutchings is saying at the bottom here, he's valuing the net crown revenues, not the rents, the net crown revenues at $59.7 billion. You see that?
Are you directing, did you
Yes,
have a
yes.
paragraph reference?
Yes, Jay.
Thank you.
Okay, yeah.
And that number, we don't need to get into why, but that's now, I think, there's no dispute that number's now been revised down to $56.9 billion. Again, for reasons we don't need to get into. Now, if you look at the next tab, down at the bottom in table 10, excuse me. Now this deals with rents. And document 2, table 10,
Tab,
tab 2,
table 10.
table 10 down the bottom.
Thank you.
So the number that Mr. Hutchings got in respect of net crown resource revenues was based on your preferred 60-40 model. And in this table, under the 60-40 equity to debt column, you see a value of $126,284,000,000.6. And so that is the value, you say, of 100% of the rents in the territory that
That's
matter to you in your analysis?
that's the value brought forward to today using the opportunity cost of capital that we talked about.
Right.
Of our conservative estimate of the rents.
Right.
These are not the total rents,
Okay,
but we had problems, as we say, estimating the rents. And so at a number of points, we had to make assumptions. I believe the real value was greater than that. And these are only the economic values, but these are the estimates that we used. These are the present value in that way.
this is the number you are asking the court to deal with, correct?
It's the value of what the Anishinaabe brought to the table.
And on your preferred sharing model, then 84% of this would be owed to the Anishinaabe, and that would be $106 billion.
No, the augmentation clause has a provision that's limited without loss. And I didn't calculate what that would imply. So this is just what they brought to the table, what they would have gotten if they had the sharing that joint venture model provides without adjustment for the other aspects of deprivations that I talked about.
Right.
And without taking into account the without loss provision. This doesn't look at that particular aspect
understand
of
that. But this number then is $106 billion, 84% of that number. Of
That's right.
129.
I mean, that's arithmetic. I'm
Yeah.
not doing it right now, but I didn't do that calculation, but I assume you're right.
Now, the next tab, document 3, I want to call up the Court of Appeal reasons. This is in the joint documents book at Exhibit 1, and it's at tab 0464. Joint document book, Exhibit 1,
Is it, and it's tab 3 in your,
tab 3 in my little binder here, and
thank you.
tab 0464, Your Honor, in the actual electronic JVD. Now, there's no dispute the Court of Appeal released its decision in November of 2021, correct?
That's right.
And you, of course, reviewed the decision before doing your opening report in January,
I did review the decision. Yes.
before doing the report.
I can't
I mean,
remember
you
exactly.
don't remember when you reviewed. All right, fair enough. Now, let's look at this paragraph 94, Professor. This is where the court starts to lean into its dispositive decision. The court here says in paragraph 94, finally, on the issue of remedies in the stage 1 proceedings, Lowers and Pardue, justices of appeal with whom Horrigan, justice of appeal, concurs, conclude that the trial judge erred in directing as part of the judgment for the stage 1 proceedings, the payment of annuities corresponding to a fair share of the value of the resources in the territory. See that?
Yes.
And it goes on further, the trial judge also erred in directing in the judgments the tax revenues and costs of infrastructure and institutions should be excluded from the calculation of net crown resource-based revenue. Do you see that?
That's right.
And that they go on to make a number of deletions and amendments to the judgment, which are reflected in the formal order of the court. And I want to move to the formal order of the court now, which is the next tab in the binder, tab 4. And this should, I think, be marked as an exhibit. There would be no contest. This is an authentic reproduction of the order. I don't think it's in the joint documents book. I could be
Do we
wrong.
need it as an exhibit?
Yes. It's in
Oh,
the
it's in
trial
the trial
record. Okay, so
That helps.
that's fine. Now, if you first look at page 2 briefly, Professor.
Yeah.
You see at the bottom, paragraph 1, the mechanical exercise, basically, where the court just says that the stage 1 orders are to be amended in accordance with Appendix A.
Yes.
Okay. And if you flip over to page 6, we get into the judgment that matters in this case. And I direct you to paragraph 2 in that judgment where it says the plaintiffs acknowledge that in addressing this motion, the parties were permitted to address and seek determination of particular issues, including in item B, it says whether the revenues that are be taken into account in determining whether the territory subject to the treaty produced or produces an amount which would enable it to do so without incurring loss are restricted to crown revenues from the territory. So that was to be discussed by the parties. Right?
Yes.
And below that, whether we're talking about gross or net revenues, also to be discussed by the parties.
That's right.
Now, if you would, look over at page 7, please, at the top. Now, here we have the court beginning its judgment, and it says, on being advised by counsel for the parties near the outset of the summary trial that there was no dispute regarding issues 2B and 2C noted above. And that in relation to those issues, the parties were in agreement that the revenues that are to be taken into account in determining whether the territory subject to the treaty produced or produces an amount which would enable it to do so without incurring loss are net crown revenues from the territory. You see that?
That's right.
And if you go over the page 8, and you look down in item C, the fiduciary duty element of the stage 1 trial judgment has been struck through. It has been amended. You see that?
Yes.
And you recall reading this judgment? Have you ever read this formal order
yes.
of the court?
Yep.
Yeah. And now, if you look at 1D, immediately below the fiduciary component, it says, the Crown must diligently implement the augmentation promise. And that's it. That's how it reads as we stand here today doing this trial. What's struck is, so as to achieve the treaty purpose of reflecting in the annuities a fair share of the value of the resources, including the land and water in the territory. So what's struck is, so as to achieve the treaty purpose of reflecting in the annuities a fair share of the value of the resources, including the land and water in the territory. See that?
Yes.
And the court obviously could have just struck the word fair, couldn't it?
Excuse me, I'm objecting to that question.
Why?
I'm objecting.
We'll hear
because-
it.
Why?
I'm objecting because what the Court of Appeal hypothetically could or might have done, indeed, this whole line of questioning is really argument. If my friend wants to argue with me about what the Court of Appeal judgment means and how compensation is to be calculated, that's argument. It's not fair to an economic expert to start talking to him and eliciting questions about what the Court of Appeal may have done. So I think it's an unfair question.
Your Honor, a huge element of this case, it will not have escaped anyone's notice, with possibly my exception of my friend.
We're not going to do that. in
It
this trial. Mr.
concerned.
Marcello,
All right.
I'm speaking.
no,
We're not going to do that in this trial.
Okay. A huge part of this case is how the experts interpret and apply the Court of Appeal judgment. It's very, very important. It's in the professor's report.
Yes.
So I'm asking him questions about how he digested this order.
Well, I'm actually having a hard time with these questions. Witness takes his instructions from counsel. His instructions are on the record and he's acknowledged them.
Right.
And if the instructions misinterpret the Court of Appeal, that's a matter for argument.
Well, we'll come to that. We'll
But
come to that.
but this witness cannot be asked his view of whether the Court of Appeal could have done something with the judgment.
All right, but it says what it says, and we've covered that.
Well, in
strike through.
fact, when you say it says what it says, it's on the record.
Yes. But I have more questions for him rising.
Well, if they're appropriate for a witness who is not the instructing counsel, go ahead.
The bottom line is that your economic rents value approach, it goes beyond what is said in the Court of Appeal judgment, doesn't it? You
Objection.
calculate
Sir,
stuff that goes beyond net crown resource.
I'm
revenues.
just going to ask you if, when there's an objection, that you stop.
The
Yes, sir.
objection presumes that the court, what the Court of Appeal intended by its judgment. If my friend is intending to elicit that Professor Stiglitz did the calculations he did on instructions from me, we accept that, we own that, but asking him to interpret the Court of Appeal judgment is not fair.
Mr.
Your
Grover,
Honor,
Ms. Evans, do you wanna
again,
jump
these
in
are
on-
not ordinary, I'm sorry.
Mr. Gover or Ms. Evans, do you want to jump in on that?
Thank you for the opportunity, Your Honor. No.
Thank you.
No, thank you very much.
Thank you. Mr.
Yeah,
Marcello?
These are not ordinary witnesses, Your Honor. The economic witnesses in this case are not ordinary. They have obviously high intellects, and they are able to read a case, and they are able a decision, and they're able to position what they are saying in their reports within the framework of that decision. So I simply asked him to confirm that what he's doing goes outside what is literally provided for in the amended Court of Appeal judgment. That is my question for him.
And in reply? So you're on-
What's provided for in the judgment is a matter for argument, which is why it's an unfair question. He's not a lawyer. He's not the judge. He's here giving an opinion based on assumptions, based on questions we asked. And if we ask the wrong question, we own that. But it's not for the witness to interpret the Court of Appeal judgment. And it's not for, the question was, it went beyond what the Court of Appeal did. That's argument.
My worry, Mr. Marcello, is you're eliciting evidence that I find not relevant to me. This witness attends here under instructions and signs a certificate acknowledging that he has followed instructions and is here to give his best evidence to the court. My worry is that you expect that this witness either took the Court of Appeal decision and looked at it independently and assessed whether his instructions were good, or took the Court of Appeal decision independently and decided how to do his work. But you haven't elicited the answer that this witness was guided by anything other than his instructions. He said he reviewed the decision, but I think you are asking questions based on assumptions that you don't have a foundation for. And at the end of the day, if the evidence of the witness goes beyond what the Court of Appeal says, it matters not to me whether Professor Stiglitz agrees with that or not.
All right, I take
You'll
your, I
make
take your,
that
I take your last point. I take.
Right.
Let's address, put aside the Court of Appeal order for now, just go into a different kind of world. Let's address the maximization of rents. And on the fiduciary point, some of what Justice Horrigan said, it's in tab 5, may be a meaningful part of the discussion. And just to refresh everybody on what he said, and this was in connection with the fiduciary point, as I think I said. He says at 599, this is tab 0464, again in the joint book of documents, Your Honor, Exhibit 1.
Okay. Sorry, I just gotta get to tab 5, thank you.
The trend in the jurisprudence is to move away from imposing fiduciary duties on governments in implementing their policy obligations. And over a couple of pages, Professor, 603. Pursuant to their rights under ad hoc fiduciary duty, the beneficiaries would be well within their rights to insist on total compensation of all net resources and take the position that the Crown has no right to benefit in any manner from the development of the lands subject to the treaties. The Crown would be obliged to strictly account for and pay out all monies received over and above the associated expenses. There would be no sharing in the circumstances. The Crown's only obligation would be to the treaty beneficiaries. See that?
Yes.
And then he goes on, in addition to the proceeding, the beneficiary's right to compensation could arguably exceed net revenues. As a fiduciary fulfilling its standard care of utmost good faith, the Crown's obliged not to benefit itself or third parties at the expense of their beneficiaries' interest. And over at 606, the beneficiaries in these cases, as there were then two, could argue that they're entitled to the revenue generated and he underlines that, and what revenue could have been generated by the lands covered by the treaties. For example, an argument might be advanced that the Crown set mining rates at too low a level in order to attract investment, create good paying jobs, and generate tax revenue. Arguably, such policies prefer the interests of the Crown or those of third parties over the interests of treaty beneficiaries. The Crown would have the onus of establishing why its policies did not amount to a breach of its fiduciary duty. In that regard, its arguments about its public policy motivations in setting its mining royalties would be of no moment. And finally, based on the foregoing, it's clear that the trial judge's finding of a broad-based substantive duty cannot stand for two reasons. First, the imposition of such a duty places the Crown in a conflict of interest. It forces the Crown to prefer the interests of one group over all others in making policy decisions regarding the development of a large swath of the province. Now, it's clear from the judgment we went through and from the reasons of Justice Horrigan that the Crown had no fiduciary duty. We're past that now, correct?
Again, if you're going to object, it says what it says. The judgment says what it says. The interpretation of what one of the minority judges said in respect of fiduciary duty is of no moment for this witness. It's unfair. If there, I just don't see the relevance of this.
Mr. Marcello, all I'm saying is, if you give anybody 4 paragraph, read it. If you ask anyone to read 4 paragraphs of an Ontario Court of Appeal decision and ask them to come to a conclusion, I think it's unfair. I think you can ask this witness, so your understanding from counsel that we're not looking at fiduciary duty, or you can argue that.
All right. Is that your understanding from counsel that we're not looking at fiduciary duty?
That's right. What I did is calculate, I followed what I was asked to do, calculate the value. I was asked framework for thinking about sharing. In thinking about sharing, I did raise the issue that I put under the category of tax expenditures that one needed to consider when funds were not, when revenues were not collected. But I didn't use the vocabulary of fiduciary. It was one of the things that I think the court needs to consider in deciding how to appropriately share the revenues.
Thank you. Tab 6. I'm referring here to your reply report of January 24, 2023. This is the 6th tab in the binder, Your Honor, and it was marked as Exhibit 4 last Friday, February the 3rd. You say here, Ontario and Canada's experts. This is paragraph 16 in your report. Ontario. Tab 6.
Got it. Thank you.
Ontario and Canada's experts claim that in relying on an economic rents approach, we're suggesting the Crown should have changed its policies to fully capture resource rents. While resource rent taxes are an efficient means of managing resources and generating revenues, we do not argue that the Crown should have implemented them. The Crown had multiple objectives and multiple ways of raising revenues, and in the pursuit of its objectives, within the instruments available or perceived to be available at the time, it might well have rationally decided in its own interest not to maximize the direct rents received. Right?
That's right.
You're aware of that paragraph. So then, am I right? You appear to accept that the Crown had an obligation to act in the public interest?
I'm not saying that, but that is a general obligation of the Crown to act in a broad public interest, yes. But that's not what I'm saying here. I'm just saying here that there was no obligation to maximize the rents and the direct Crown rents. And that's all it says. And it just says in our calculations, we just took things as they were.
And in the beginning of the second last line of paragraph 16, where you say decided in its own interest, you mean the Crown's interest. You mean the public interest when you say that? Do you consider the Crown interest and the public interest to be the same in essence?
I don't see there being any distinction, but it's not a question that I actually addressed.
All right. And I understood you to say last Friday that you had no reason to infer bad faith on the part of the Crown in terms of how they collected revenues. Is that right?
That's right. But that is to say, I didn't want to make any inference. It was not a subject I studied.
All right. But now, in spite of what you said here, we do have you taking a position in the witness box and the superior plaintiff's this action taking a position that the Crown needs to account to it in part for these economic rents that were not turned into Crown revenues, right?
Yes, I mean, the example that I gave in the hydroelectric, I think it was a good example of that, where it had three ways of doing the same thing. Making sure that electricity was available at a low price. And one way, a direct subsidy, they're all equivalent, except to the extent that one of the ways has the effect of depriving the Anishinaabe of revenue that they otherwise would have received. And in thinking about those three ways, if they chose one way rather than the other way, a way that is less transparent and not as good from the standards of good governance and public finance, if they chose one way rather than the other, the court ought to take that into account in deciding how the monies that are available to be shared, i.e. the total resource revenues, should be allocated.
So the court, in essence, you're saying should review and substitute the Crown's policy decisions?
No. It needs to take into account the way the Crown made that decision on the allocation of funds to the Anishinaabe. It's not saying that it needs to change those decisions. It just says it is a factor that ought to be taken into account in the allocation of the rents that are available for to the Anishinaabe.
But sir, you want, not to put too fine a point on it, you say the Crown should pay for the fact that it did not get as much in revenues out of these exploited resources as you suggested it could have. You do say that. I think that's.
No, I don't.
Well, what's the 84% of $129 billion for then?
Well, 84% of the $129 billion is the share. The 129 is what the Anishevik brought to the table. And then we say, here is what the share, the appropriate share that they ought to get in that framework. And there's another framework where it's 58%, and that's not taking into account relative deprivation. So there are some other adjustments that ought to be made. But if you take that as a starting point, 84%, then I'm saying there are a couple of other provisions that you want to take into account. You have that without loss provision that might bring that number down, because
So,
that might be not possible to do without loss if you include both direct and indirect revenues. And then I'm saying that of the amount that you could do without loss, you might want to raise that because they've diverted some of that in their tax expenditures decision.
is it your understanding that the plaintiffs in this case are claiming 84% of $129 billion? Is that your understanding? Yes?
I'm not sure what they're claiming.
You're
I'm
not
just,
sure what?
I wasn't asked that. I was asked the question, what is the value? What is the sharing framework? That's
And-
that's their decision.
And the other way you say the Crown should pay is if, I thought you said if they didn't have to pay the 84% of 129, well, then, you know, the value as you describe it of these rents, including the uncaptured revenues, well, then that should influence what share of the net Crown revenues they get. I think I heard you to say that. So that you have kind of a two-pronged approach to how the Crown has to account in your model here, right?
You
In
can
essence.
think of it as 3 steps in the analysis. The first step is, what is the total value? What did they bring to the table? And we have a conservative estimate of that total. That's the total that the Anishevik brought to the table. The second step is the sharing. And there are several features. We talked about that at the end of yesterday, how it depends on the extent of alternative suppliers and managerial services, the extent of risk taking, risk sharing that we talked, and the extent to which you adjust for relative deprivations. So we had a risk sharing framework. And then the third step that we didn't talk that much about is there is a provision in the augmentation clause without loss. And that then puts certain constraints on how the value that I calculated that should be shared is shared.
Okay.
And that has to do with the sharing of the allocation, you might say, of the total Crown revenues, net Crown revenues, resource revenues. And in that allocation, if the way they do it, the way the Crown manages affairs is such as to deprive the rents. It's the story of Bob, the apartment. If he gives us to his niece, gives the apartment free to his niece, you adjust the amount of the rent that's divided in that pool accordingly to take that into account.
Right.
It's really a very simple, you might say, 3-stage approach.
Okay, but you don't accuse the Crown of renting the apartment on the down low, right? That's where you didn't say that in your evidence.
Well, what I'm saying is they
did.
decided for one reason or another to not collect rents that they could have collected.
Sure,
That's,
but
I'm not impugning why I didn't analyze why they do it. Most economists say that was a mistake, but that wasn't part of my purview. I'm saying it was what it was, but that shouldn't be on the back of the Anishinaabe.
Sure, but there's a big difference between Bob putting $1,500 in his back pocket apparently unknown to his partner and anything. I mean, you have not accused
Well,
the
I
Crown
do
of
think that
that.
there should have been, my reading of the understanding was there should have been a lot of discussion between them.
Right.
There wasn't that discussion.
So,
And if there had been a discussion, maybe things would have played out differently. But what I am saying is that this concept of tax expenditures occurs all the time in all countries, and one has to take that into account.
Yeah.
That's all I'm saying.
when we go back, just wind it back a little bit, you don't know whether the plaintiffs are claiming 84% of the net Crown revenue of the rents in this case based on the 64 mile. You said you don't know if they're claiming that, correct?
Well, I don't know precisely what they're claiming. They're going to be claiming, I think, what they can within what their interpretation and the court's interpretation of what the treaty is. That's what they're going to be claiming. But the basis of that is evaluation. I did the economic valuation. The basis of that is an analysis of the sharing, appropriate sharing framework. And I did an economic analysis of what reasonable parties would have brought to that sharing analysis. And beyond that, I'm here just as an economics expert.
You recognize the Crown's obligations to act in the public interest. That is clear. We've covered that some eight minutes ago or so, I would guess, right?
Yes,
No disagreement there.
But there are other in the public interest that it's supposed to, there's language which I'm not a lawyer, but there's a discussion of the honor of the Crown. There are many other factors that the Crown has to take into account.
But you remain of the view that even if it's just how the net Crown revenues are to be divided, you are saying that these economic rents that you factor into value collide with that. They have an impact on that. They're a factor to take into account in how even net Crown resource revenues should be shared. You have said that, I think. Is that right?
I'm not sure I followed your
So
question.
let's say the court decides that net Crown resource revenues are the pie.
The
And we
pie
have-
to be shared.
Yes, we have all those numbers through an
I think
awful
that
lot of
would-
work, as you pointed out. But we have those numbers. I'm sorry, sir.
So if they decided that the dollars to be actually allocated are limited to the net Crown revenues, is that what you're
Yes.
saying?
If that was what was decided in this,
That was the
course.
amount that could be allocated, the maximum.
yeah, the net Crown, so go back and use Mr. Hutchings' $56.9 billion being 100% of the net Crown resource revenues, using your optimal 60-40 stock and equity bring forward, I guess I'll call it, multiplier model. Assuming that, you still say that the Crown's, I'll call it the failure, or not to maximize rents on exploited resources, it still has to be factored into how that $56.9 billion is shared.
No, because I never
don't.
said that the numbers that we were working with were the numbers as they were generated. The ranks, we didn't make a judgment about whether they managed the resources optimally, whether they could have done other things that would have generated even more rents. We're just calculating the ranks as they were generated. Now, what we're saying is if that 83% is more than the net Crown resource revenues, then an appropriate allocation sharing would be to give all of those net ground resource revenues.
Okay.
The
so
direct,
I think what you're saying now falls within the box that I put to you. I'm going to move on. I'm going to move on. Now let's get more pedestrian just for a minute. Let's just bring it down from the 100th floor. Even if you want to collect 100, even if somebody wanted to collect 100% of the rents, you agree that that's no easy thing to do, right? That's no
we
walk
never
in the park.
assumed that we would collect 100% of the rents. And we actually, as we pointed out, what we measure is the rents that were actually generated, and 40% of the time, we used the numbers that were actually the net ground resource rents.
Yes, I took that point from your testimony. Thank you. So but you agree there are information deficiencies that exist in this to and fro between the collector and the mining company or whatever. For example, corporations, they know their real expenses much better than the Crown knows their expenses, right? Stuff like that. You've dealt with this extensively in your resource curse book. It's cited, some of it's cited in the Smart and Bodway June 30th report. I think I can't remember the paragraph
Yeah, I know the
51.
paragraph. Yeah.
You remember they footnote to your article about the Alaskan oil situation. I've read that. It was very interesting. And this is the kind of thing I'm talking about now, that people just don't want to pony up money. They fight to keep it. It's not easy to just maximize rents, right?
That's right.
There's tax avoidance, which is kind of this elevating expenses thing.
Yeah.
And there's environmental issues and protests that happen that can make it difficult to exploit resources, right?
That's right.
There's flat out tax evasion too.
Yes.
So I put to you, for the Crown to have agreed in a treaty to pay annuities based on rents it might never collect, that wouldn't be an astute financial decision. You would agree?
Well, what we measure is not, and when we're talking about rents, we talk about things that were actually reported. So it's the mining company profits, taking into account that they may have engaged in evasion. It's the logging that's reported, taking into account that somebody may have gone out into the forest and taken down some logs, and that's something that value, but we don't record that in our rents. So we know, both sides know that that's going to happen, but it's not a concern. It's not really an objection to what we've done. We've done here what is observable and in that sense, to a very large extent, taxable.
Can I just see if I understand that last comment? You say you're not going down, you're not counting the logs somebody cut in the forest that didn't collect. You're saying, I think, correct me if I'm wrong, you didn't account anything that wasn't reported as what?
We're not reporting as rents. There's a concept of value out there that's somewhat abstract, but now we implement that concept.
Yes.
And to implement that, we have to use available data. And people who are stealing logs, those are not part of the rents that are going to be included in our rent number.
Okay.
And so that's not an issue. If the mining company is not honestly reporting mining revenues or dishonestly reporting expenses, that's going to show up as lower rents in the mining sector. So these problems are already reflected in a diminution in the value of rents as we reported. So this, in my mind, and we discussed that in our report, this is a red herring about not being able to collect all the rents. We're not reporting on all the rents. And the question is the amount that we record basically collectible? And there's been no evidence that that diminished amount that we report is not collectible. In fact, as I pointed out, 40% of the time, we just use the amount that was actually collected.
So to bring it down to earth a little bit, if parties are on the ground in 1850 and they're considering some sort of an arrangement, I'm going to put to you, I'm going to ask you whether you agree with, I'm going to ask you if you agree with this. I mean, for a party like the Crown to agree to pay, possibly pay augmented annuities on amounts it might never collect, that is economically irrational, I suggest to you. I mean, knowing what you have in hand is one thing, but agreeing to pay annuities based on stuff that's just out there in the ether, that's not economically rational, I suggest to you.
It would be if, let's go back to the basic notion of the landowner, and the way we talked about the landowner is he can get the value of his land. And it is economically rational if I owned a land to say, yes, I'll share the value of the land. And in this particular case, there was a provision about without loss, and that without loss provision protected them because it's without loss, including, in my interpretation, both direct resource revenues and indirect resource revenues, and that protects it.
But your indirect resource revenues, they come on the positive side of the equation. I mean, you're counting them as you're counting them as having value. And you're saying, if I understand you, and I actually think I do, the Crown has to account for what I think you're calling these, it has to account for rents. It did not turn into revenues from, let's say, from, just take one sector, mining companies. Maybe it charged, in your view, mining profits tax that was too low. That would be like the stumpage example I began the day with. So you factor in what they should have charged when you conclude how this augmentation clause works, right?
Not quite.
How close am I?
A big distance in money terms.
Oh, money.
The point
concept.
is, if you charge zero, that rent doesn't disappear. Remember what I explained,
Yes.
It doesn't disappear. It goes into the pocket, in this case, of the mining company, but it might in other cases go elsewhere. And the Crown recaptures a significant fraction of that, which we can estimate fairly reliably, but it's a significant amount, 25 to 35%. So that's part of the resources that are available. Now, so if you look at it from the point of view of the Anishinaabe, if they said, this was my criticism of the narrow reading of the augmentation clause, that says, would you sign an agreement with somebody who says, I'm going to decide, I have the complete discretion not to charge any direct revenue collection mechanisms, you get zero then. Well, you're giving up something worth $129 billion in return for equivalent of $4, $1.60 a person. And that's it forever, because the augmentation clause says you get nothing because they've lowered the direct resource revenues to zero.
So
nobody in the right mind would sign that.
The Crown gets what it gets in your example. It gets what it gets in revenues. And you say, take your high watermark, it gets 35% indirect. I don't know if that's right or not. I don't accept that it's right. I don't know. But let's say for now, it's right. So you got 65% of these, 65% of something that's still not been turned into revenue by the Crown, right?
That's right.
And you say the Crown would have entered a treaty recognizing it would have to account under the augmentation clause for that 65%.
No.
You
No, without law says they, let's say that 35% is the right number. They get, the Crown gets 35%, and then reading the treaty with the without loss provision in the augmentation clause, they get the Anishinaabe are due 35% of the value of the resources. Or let me put it, whichever is lower, the 35% of the rent or the share that we calculated, which in my formulation is 58, is 84%, but in some of the other formulations could be 58%, and then adjusted for the deprivations.
So you're saying the Crown's got to give back what it collected in that's taxes, mining profit taxes, et cetera, whatever the constituent elements of that 35% are, that's got to be thrown back under the augmentation clause. You're saying that?
What I'm saying is, it is a recapture. They're not obligated to do it, but it is what they are recapturing today under the tax system. It is part of the recapture, and there are many ways of recapturing.
Yes.
It could be through, but I'm not saying that they have to adjust the taxes to do the recapturing. It is what they are recapturing.
So
Under the economic frameworks,
and yet
tax laws,
we seem,
whatever that they have.
I'm sorry, and yet we seem to be facing a claim for 84% of $129 billion.
I'm not, you'll have to talk to the attorneys about what they
Okay.
are claiming. I'm just answering what I think the value was, how it should be shared, and then there are these loss limitations.
I'd like to talk to you now about a different area. Your bargaining framework. I know you, in your report, I've got it in, I've tried to get the guts of this in one place at tab 7. And it's exhibit 3, it's part of exhibit 3. It's on page 74, where it starts anyway, paragraph 156, and it goes through to 161 to 170. And this is your, not gonna go into this in a lot of detail. The excerpts, that is. Now, so we're in your bargaining framework here, and you go through the Nash thing, as I recall. And then you go through some like modified Nash thing where you come up with 58% or something like that, which brings back in the value of the land, if I recall. Right?
Yes.
But then you land on what you say is the thing that should be the model here. And this is your joint venture model. That's where you land, right?
That's right.
Okay. So are you aware of proceedings in the Supreme Court of Canada in 1895 concerning this treaty?
I'm aware of them. I haven't read them.
Are you aware of the proceedings before the Judicial Committee of the Privy Council in 1896 concerning this treaty?
I'm a little bit aware of that, but again, not very.
The Privy Council said the beneficial interest in the territories ceded by Anishinaabe under the treaties of 1850 became vested by virtue of Section 109. That's the British North America Act, as they used to call it. It's called the Constitution Act now. Became vested in the province of Ontario, and that vesting was not subject to any remaining interest in the land on the part of the Anishinaabe. Are you aware of that?
I think I may have read that. Yeah.
Okay. And do you accept that after the surrender, the Anishinaabe did not retain any interest
I
in the
have an
land itself?
objection.
And
Yes, sir.
yet this is a legal question.
Yes, the
Okay.
objection is legal question. You're asking him to interpret what the Privy Council did or did not do.
Well,
I was waiting for Canada to stand
I-
up and that.
I think that I won't ask him to, because it does speak for itself. Only because he said I think he's quite capable of interpreting what it said. Clearly an extremely bright individual, to say the least.
Although,
But
just
I
saying,
got
Mr.
your point.
Marcel, I would be very cautious,
I-
having heard that read to me,
Yeah.
interpreting that. Whether,
So-
whether someone is intelligent or not, I would be very cautious.
Well, he said that he hasn't, I think he said he hasn't read it, so I'm going to not ask any more questions about it. It speaks for itself.
Thank you.
When you speak about in your report, and you spoke a lot about it in your evidence, I think particularly Friday, management, and management fees and managing lands and so on, recall?
Yes,
And you speak in the report of the Crown managing the lands for the benefit of the joint enterprise.
yes.
Now, I'd like you to take a look at tab 8 in the book. This, Your Honor, is part of Your Honor's reasons from stage 1. It's in the JBD, Exhibit 1, and it's at tab 0003.
Sorry, did you give a paragraph reference?
512. I don't,
Thank
it's in the, it's in the book. Oh, but I didn't highlight it in the book. You're
Thank
right. 512. So if we just look at that, Her Honor says here, and this was in the context of her consideration of the fiduciary argument. Specifically, I find that neither the treaty's text nor the context in which the treaty's promise was made support the contention that the augmentation clause included the notion or concept that the Crown would administer the land on behalf of the treaty's beneficiaries. In the absence of an undertaking in respect of the cognizable interest in the land, I find a sui generis fiduciary duty does not arise from the Robinson Treaty's promise. Have you have read the trial reasons from stage 1 at some point, most certainly,
Yes,
but perhaps have not zeroed in on that particular paragraph recently.
I can't remember, actually.
You don't disagree with what Her Honor says there about administration of the land on behalf of the treaties. You do not disagree, is that correct?
I think that's a matter of law.
I'm a lucky judge. There's no question. I get to see what the Court of Appeal thinks about me. I get to hear what you think of it. But really, I can't imagine a witness agreeing or disagreeing with what I said about a sui generis fiduciary duty.
Oh, I'm not asking
Who's
about
not?
I'm asking about the management of the land.
No, you asked if he agreed or disagreed with that paragraph.
I'm asking him if he disagrees with you when you said there was nothing in the treaties requiring the administration of the land on behalf of the treaty beneficiaries by the Crown. Do you have a
Mr.
different
Schachter.
view of that?
Mr. Schachter is making an
Not for
objection.
This economic expert to opine whether the trial judge would like or what their interpretation of what the trial judges are, how the court feels. Just a pain problem.
The treaty itself doesn't mention managing the lands, does it?
Again, objection now be
Oh.
asking for an interpretation of the treaty. We're not a lawyer, not a judge.
We're going to take a break. Mr. Marcello, if this is difficult for you, have a coffee, take a break, and we'll come back. 15 minutes.
Thank you.
This court will recess for 15 minutes. Thank you.
Right.
This court is now resumed. You may be seated.
Tab 10 in the binder, please, Professor. This is Exhibit 3 again.
Yes,
Paragraphs 161 to 163. I'm going to take a look at part of 161 here. You say here, beginning 1, 2, 3, 4, 4 lines down, halfway in, the Crown in 1850 behaved as if it had two choices. One, assume the full economic risks and rewards of ownership of the lands and resources and compensate the landowner in a way that they're relieved of all risks. Or two, share with the prior owner of the land and resources the ongoing risks and rewards, similar to an early stage investor buying a piece of a startup company. Whatever the Crown's reasons in 1850, it chose option 2, right?
yes,
And so you're talking here about risks and rewards in general, right?
yes.
And if I understood your testimony, where I think it may have been more, the point may have been more clearly made, if I may say so, than in your report, you put the Crown risk basically at having to cover the flat amount of $2,000. Is that
That's right.
okay? And when there, and your report doesn't, and forgive me if I have missed it, but your report does not adjust for your risk analysis for the $4 that was paid beginning in 1875.
No, what we say is that there was essentially no risk. And the reason that the number was increased by 1875 was the land was producing more than that amount. So
Yes.
by that time, risk had disappeared totally.
Yeah.
So this is the risk that was perceived, that might have been perceived in 1850 when the risk going forward. But as I pointed out in my testimony, there was really very little risk because the money was coming in. It was clear that the mines were there. That was part of my reading of the history of the moment. Was it was the miners were moving in, they wanted the land, they saw that it was valuable. So that risk that the Crown was assuming was de minimis. And in fact, one of the things that we point out, by 1875, they were able to fund an annuity, they would have been able to take the revenues they got and have a
6,000.
trust account that would have yielded $6. So that just shows you
$6.
the diminished nature of the risk. So when we said 16% for the Crown, that was a gross overestimate of what they, you might say, rightfully should have been compensated for bearing that risk.
Right. Now, risk is examined in a prospective way, though, right? You're looking forward when you're looking at risk, right? And the
That's
farther
right.
out,
But you know something at that moment of time.
right? And you said yourself, if I recall your evidence, that I mean, you used a number of numbers, but I think you said your bottom line was out beyond about 25 years. You really couldn't predict much, and right? You couldn't. That's
The parties to the agreement knew that they didn't know.
and to the point of being on the ground in 1850 and assessing risk. You are aware that in 1850 the revenues to the Crown from the territory were $0, and in the next year they were $1,216, and the next year they were $0. This is in Hutchings Table 17. Have you looked at that?
Mr. Schachter
Yeah,
is up.
sorry, my objection was I didn't believe that the evidence at trial was that the revenue was 0. And if my friend wants to take the witness to what Mr. Hutchings viewed, I think that's fair, but I don't think it's fair to summarize that the court said, or the evidence was that there was no
I'm
revenue.
not summarizing what the court said. I'm just paraphrasing part of Mr. Hutchings' report. I take your point that in the fullness of time, hindsight, whatever you want to call it, looking back, the numbers covered. I take your point on that.
And with the point I was making, cover fairly quickly, and in 1850, they would have been able, there were already people coming in to wanting to develop the mine. So with the point that I was making is a 25-year perspective is not a very long perspective when you're talking about a mine. And the fact that within that 25-year perspective, they were able to, they would have been able to fund this trust fund that would have paid $6 a year forever, suggests that there wasn't very much risk. And besides when they later discussions that we were talking about a little bit earlier in the latter part of the century, look back, they said they should have been paying a higher number from the very beginning. So that suggests to me, without, I didn't have time to read all those proceedings, but that suggests to me that there were revenues available.
Right. So the old chestnut hindsight's 2020, but I'm saying when you're assessing a risk on the ground in 1850, it happens to be a year where, as a matter of fact, according to Mr. Hutchings, the net crown resource revenues in the area are 0. And the next year they don't cover the 2000, and the next year they're 0. Then they kick up and they're a bit erratic. And I have your point about overall looking back. I got it. But looking forward, I mean, it didn't get off to a great start, I suggest.
Well, mines don't take a while to develop,
Okay.
and the whole reason why, as I point out, that there was a strong demand to have some kind of a settlement, a treaty, was that people saw that there were valuable resources there, and it's the value of the resources that we're talking about. And yes, it's possible that they might not have turned out, but remember, what they were putting up was $1.60 per person, when all the calculations show that their frameworks are much larger than that. So it would be that the return was a fraction of what everybody thought was the value at that
I
moment.
understand your evidence. I understand. Thank you. Now, you, in paragraph 162 over the overleaf 1, you say, we understand the Crown began paying annuities on a population model to First Nations in 1818, rather than one-time distributions. So the annuities model begins in around 1818, I think is what you're saying there. And however, we also understand that these initial annuities were fixed sums and were not subject to augmentation like the treaties. The Crown paid approximately, excuse me, $10 per person in these treaties. And that $10 was fixed from 1818 to 1850. You with me there? And you have a footnote one. I'm sorry, we're going to say something. You have a footnote there. I was just going to take you to. You footnote into Her Honor's decision in stage 1. And that is the next document at the next tab, 11. And you're back to the joint book of documents at tab 0003. Again, the trial reasons from stage 1. And just to refresh everybody's memory about what Her Honor said some years ago now, we see here, she said, beginning in 1818, the Crown changed the compensation model in treaties for land surrenders. Annuities were provided rather than one-time distributions or payments. Annuities were expected to be funded from the proceeds of the lands that were surrendered. The Crown structured treaty payments as annuities based on a population model. The annuity is expressed as an aggregate amount based on roughly 2.5 pounds per person multiplied by the First Nations population at the time the treaty was made. The multiplier of $10 was unrelated to the value or size of the land surrendered. The first such payment was made at the time the treaty was signed. Annuities in the same amount were paid thereafter. The move to an annuity model was likely triggered by the pressures created by waves of immigration and the devolution of responsibility for paying treaty annuities from the imperial government to the local colonial government. The annuity model allowed the Crown to control its cash flow. The Crown proceeded on the presumption that the land sales to settlers would generate sufficient funds to finance the annual payments in perpetuity. The same multiplier was used from 1818 to 1850, irrespective of the size or value of the land, irrespective of the size or value of the land. Now, I don't know how much of the historical record you've gone into in this case. You may be able to assist me with that, but I suggest to you that there is no evidence to suggest the Crown in this case ever entertained the notion of paying $10 a person under the Superior Treaty. Are you able to comment on that, or have you not reviewed the historical records sufficiently enough to do that?
I don't think it's really relevant for my analysis. $10, if you ask the question, for our analysis, going back to our joint venture model, the $10 is a conservative estimate of the value. We did, even using the methodology that Bodway and Smart use, but correcting for the peculiar treatment of logging expenses and a few other things, you get numbers well in excess of $10. So the notion of, there are two aspects in our two numbers that go into our analysis of whether 16% is an appropriate compensation for the Crown for bearing risk. One is, was there risk? Our analysis is very little, and that numerator being very small means no matter what the denominator is, that share should be small. And the denominator is, was the value of land greater than $10 a person, equal to or greater? And it's very hard to, come up with a number that's less than $10. So when you look at both of those, the 16% seems to me a very conservative number.
But you still take this $10 from treaties and you apply it as one of your benchmarks. And then I ask you again, are you able to tell me that from the historical record, you think the Crown ever seriously entertained paying $10, or are you simply saying it doesn't matter to your analysis?
It doesn't matter for
It
our
doesn't matter
analysis.
to your analysis.
Our analysis is based on what a reasonable value of the land was. and-
Referable to treaties down south.
What?
Referable to treaties down south in Ontario.
What?
Referable to the $10 treaties, as you call them.
Oh, the point was the value of the resource was at least $10. And therefore, what we're asking is, if you view this as a joint venture and one party is assumed to take away a certain amount of risk, how much of a share do they get in return for that?
So
It's a simple question. And there are two numbers that go into it. How much risk did they bear? And what was the value?
But either you're
And-
doing an academic exercise, it doesn't matter whether the Crown was buying into any notion of $10 or not, or you're saying, as I thought you were, because paragraph 163 says this, those 1818 to 1850 treaties provide useful evidence for the joint venture framework. You say that about those treaties.
It's part of the evidence, but it's only part of the evidence. I mean, it is part of the evidence, but what we're saying is, and it set the frame for a lot of the way the First Nations would have thought about this, but in terms of our economic analysis, what is really relevant is what share the Crown should get for taking away a certain amount of risk. And that's the ratio that I said, how much risk did it take away relative to the value? And we did an independent analysis. That was the PDV calculations that we did of rents. And that's really what we rely on for that. And that comes out well above that $10. But the $10, if you want to think about it, is a minimal reference point. And that's really all we're using that for.
So,
We say, if we had used other numbers like 20 or 30 or the numbers that come out of our analysis, that share would have been much smaller. So our intent here was to try to come up with a,
I'm going to
I'm sorry, Your Honor, I'm having trouble getting both the witness and counsel. They're overspeaking quite a bit.
The usual rules apply. Go ahead.
so you finished?
I was trying to come up with a reasonable, you might say, a reasonable conservative number. And $10 seemed to be a number that everybody, I thought, seemed to agree on as a basis. But if you don't want to use that, and you want to go to our calculation of value, that's fine. And then you get a much smaller number.
But you do say the treaties provide useful evidence for the joint venture framework. It shows the Crown was paying $10 per person when the Crown bore all the risk. You do
Yeah,
say
we're-
that, right?
That's right.
Okay, so I want to move on and I want to ask you, because I didn't notice it in your report. I didn't notice any reference. I noticed the footnote to Her Honor's decision that we've gone through, but I did not notice in the documents supporting your report any reference to any of these $10 treaties. Is all your knowledge about these $10 treaties taken from Her Honor's stage 1 decision, those paragraphs we've gone through?
I don't think it's all our knowledge, but it's a summary judgment. We thought that we could rely on the Crown's assessment for that, but
So,
we had looked at others. If you wanted to, we had enough footnotes as it was. I don't think we needed any more.
so you've not examined these treaties, like they would be treaties like Mohawks, the Bay of Quinte, the Mississaugas of the Credit, Chippewas of the Thames. You have not examined those treaties?
No,
And these $10 treaties that you reference in your report, how would they map out for me? How would they work in year 5?
I'm not sure.
Pay $10 a head when the treaty's made. What happens in year 5?
They get $10. Well, these were annuities, so they would get $10 every year.
And year 7, they get $10.
That's right.
You're not aware then that these treaties were only necessarily $10 in their first year? You're not aware of that? That they could vary the next year based on population. If the population went way up, the amount will go down.
There were
the
some that were $10 per person. And so the population changed, the payments would change.
Which way would they change? If the population went up,
The
I
payments.
put
would
to
go
you
up.
that the $10 value would go down. This was a lump sum. These were one-time lump sum. Not, they were the same amount of money was paid every year by the Crown under these treaties. Same amount paid every year. So if the population went up, the $10 per head went down. You're not aware of that.
I rise
What?
on an objection.
Yes.
First of all, it said he did not review exact treaties themselves. Secondly, my friend is not accurately describing what the treaties say. They are in the record. Exhibit 12 was not a fair question to. It is not a fair question to summarize the evidence that was before the court. And if my friend wants to take, do not encourage this, but if we're going to talk about the treaties from 1818 to 1850, my friend is going to have to refer to a specific treaty if it's necessary for his questioning, but it's not fair to summarize them as all being the same because they weren't. And that's how I'll leave it at that.
My friend is suggesting these were different in terms of not being the same amount paid by the Crown every year. Is that what I'm understanding?
From Mr. Schachter?
Yeah.
Let me just say this. I believe that my dive into the treaties was in a huge level of magnitude, much greater than Professor Stiglitz's.
Oh, yes.
And I would not be able to answer that question. It's just not, it's more complicated than a one-liner.
All right, let me put it to you hypothetically. If the same amount was paid by the Crown every year, assume that, then the Crown had no risk of ever having to pay any more money in a year in the future, right?
Yeah, by definition.
Right, by definition. About a couple of questions, not many, about your 60/40 portfolio model. And I turn here to document number 12. Again, it's exhibit 3, paragraph 148B. This language, I don't know, in a joint report, I don't know from whom it emanates exactly. It may have emanated from Mr. Hutchings. Happy if you tell me that. 148, the objective of the calculation is to compensate someone today for money they should have received in the past. This requires us to consider the investment alternatives available to the Anishinaabe and what would have been done with the funds had they been received in a timely fashion. There are two plausible alternatives. The first one, you refer to section 61.2. And then you say, had the Anishinaabe consulted with a planner, they would have invested in 60/40 equities and bonds in a bonds portfolio. You say that, or Mr. Hutchings says that, your report says that, right?
That's right.
So, I mean, clearly, if they'd consulted with you or someone, they would have done that, for sure.
They would have probably done 100%, but
But
they
we,
didn't consult with me.
they did not consult with you. They did not have that opportunity. But you don't, as a matter of fact, know what that planner would have said, right? You don't know. You can't know that. You know what you would have done.
But we know what they could have done and what a reasonable person would have done with a long-term horizon. And, you know, whether it's me or anybody else with a long-term horizon would have said, equities generate more returns than debt. We're here for the long term. We're a country, not a short-term investor. And therefore we ought to invest with a set of investments that would have yielded that long-term return. Actually, what they would have done, given the level of deprivation, would have invested in infrastructure, education, health, and that would have yielded a far higher return. So as I explained in my testimony, the numbers here, I think, are very conservative relative to what the opportunity cost would have been if they could have actually had that money and invested it in providing for the community in jobs, infrastructure, education, and health. And so these numbers, I believe, are too low.
We've all had financial advisors in our lives, for better or for worse, right? We've all
Yes.
had financial advisors intersect with our lives, for better or for worse. I just return to the simple proposition again that you actually you do not know what such a person would have said back in the day. You cannot know that, correct?
That's correct, but what I'm saying is, what I'm trying to do here is get a view about what the opportunity costs were. And what I'm saying is, this is a lower bound on the opportunity cost. If that community had gotten together and had those resources, they would have done something that would have yielded a far higher return than I believe these numbers represent. They would have been able to invest in education and health and infrastructure and jobs. And they would have been, the returns on that would have been much higher, and they would have been much better than even the numbers that we
Right.
put here would have said.
Right. Well, you've made the point. Indeed, all the experts agree that the old money in this case has the most pop, right? It has the most value because it's the older money. If something was owed in 1851, under your 60-40 model, it's worth more than something that was owed in 1862 and 1863 and so on and so on, right? So, I mean, we've covered the planner point. I mean, I go here because I assume you know this stuff, and this is all out there to be seen. I mean, you go to the ground in 1850. What's going on? The United States has decolonized some 75 years before, and you're in it's in like a 10-year lead up to the terrible Civil War. And in Canada, we're the United Province of Canada, and we're not yet a country as we know it today. And stock market, and so as Your Honor said the other day, I think she used the word nascent country. Everything's kind of new. What do you know about stock markets? I mean, there's a London stock market since 1801 or something, right? And I don't know, was there?
Yeah, so there were equities. In fact, we give data from
Yeah.
London and the US for equities going back to that period. So they could have invested in
In London?
equities in both the US and UK, and they were
Right.
part of the
But-
UK at the time.
But in Canada, I mean, there was some sort of makeshift exchange in Montreal from 1832 or something, and then the Toronto Stock Exchange doesn't pop until what, in the 1860s, I think you would know this stuff. So, and it had 13 indices on it, or 19, depending who you believe. Like, not a lot of, it wasn't like call up the broker and say, get me into Amazon big. Like, there was limited
Yeah,
availability in Canada in terms of stock markets, right? You would accept that?
people were investing across the
Across the
Atlantic, and
ocean.
they were investing in the United
Okay.
States, and there were people moving back and forth. So there was no reason they could not have gone beyond Montreal and invested in US and
Okay, so
and
you're
UK.
talking about foreign investment here,
What?
basically. You're talking about foreign investment.
Foreign investment, but UK, you have to remember, you were it was still a province of UK, so it wasn't foreign in a
In that-
sovereignty sense.
And you would agree that if the Anishinaabe did not have control of their money, they would not be able to invest it, as a matter of fact, without control of the money.
That's right, but that would be part of the loss that the Anishinaabe had because of the Crown not allowing them to do with the resources what they could have done with them.
Can we go to the next document here, which is number 13? We've seen this before. too much paper. You gotta find a reference here. I've lost the reference. Page 7 of the order. No, the court is into its dispositive judgment. Down the bottom, paragraph 1, this court orders and adjudges and declares that considered apart from the pleaded defenses based on statutes of limitation, res judicata, and laches, including acquiescence, and without making a determination as to the respective responsibilities and liabilities of Canada and Ontario, pursuant to the Robinson Superior Treaty of 1850, the Crown is obligated to increase, and the First Nation treaty parties have a collective treaty right to have an increase from time to time the promised annuity payment of £500 or $2,000 if net Crown resource-based revenues from the treaty territory permit the Crown to do so without incurring loss. So I hope this is not considered a legal question, but you would agree that it's the ability of the Anishinaabe as a collective to invest that matters to your model. This is a case now about a collective right.
That's what the language of that says, yeah. And that's
Yeah.
why the investments that I talked about, infrastructure, health, education, are so relevant to assessing opportunity cost, and why the numbers that I used from the 60-40 model were probably an underestimate of what that opportunity cost was.
Now, you have no expertise in band trust accounts, correct? That's not your area of expertise, band trust accounts.
No, it's not my expertise.
Are you aware that the monies paid to the Robinson, the monies to pay the Robinson annuities were in fact flowed through treaty-wide accounts? One collective account for the Huron bands and another collective account for the Superior bands? Are you aware of that?
I think I'm aware that monies were put into accounts. I don't know the details of those band accounts.
Are you aware that that money was controlled by the Crown?
Yes,
He also would agree that annuities, being annuities, were typically paid out annually, not left in treaty-wide accounts typically. You have anything to say about that?
no, I don't. I do know that there was a trust that was set up, an account that was set up back at the end of the 19th century that would have allowed for the payment of annuity forever.
Mm.
And I don't know how that links with the band account.
But finally, the last tab here is something we have seen before, but this is on a different point. You, again, Exhibit 3, Your Honor, paragraph 148. 148A in particular here. Now, you say in 148A, if we back up just a little bit to just before A, maybe read the whole thing again. The objective of the calculation is to compensate someone today for money they should have received in the past. This requires us to consider the investment alternatives available to the Anishinaabe and what would have been done with the funds had they been received in a timely fashion. There are two plausible alternatives. Now, I get your preferred one. Your preferred one's the 60-40.
They,
Your preferred one, you talk about two plausible alternatives here. I understand that your preferred one is the 60-40.
Yeah.
I've taken that point from you, but you, right? But you say in A here, another plausible alternative is that, and I think there's a typographical error in here, but I'll read it literally. First, that the money was invested at the same rates as what would have been paid had Crown would held the money in trust, consistent with section 61(2) of the Indian Act. So you do allow, you do describe as plausible this Indian Act, so-called this Indian Act alternative. You do that. You do describe that as plausible.
that is a way, but would not be an adequate compensation for the money not having been paid.
But you,
And-
I'm sorry.
Yeah. So there are many ways of misspending that, of not taking advantage of the full opportunities. So maybe I miswrote and said there are two. There are many ways. And what I also pointed out, and in my testimony, that there are better ways than putting it into just money. And the better way would have been the collective to invest in infrastructure, education, health, jobs. So what I wanted there was a conservative description of what could have been done.
Right.
Not, that's all. It was just a benchmark for what could have been done. And I was trying to say that way of doing it was far better. The 60-40 way of doing it was far better than just putting it in a low return.
Right.
Given
I-
the long-term horizon of
I do.
Donna Shavik.
I do understand your preference. You have not struck me as someone who would shy away from saying very directly if he thought something was wrong. And you do not do that with respect to the Indian Act. You describe it indeed as plausible, right?
It's one of the things that could have been done, but would not have been the right thing to do.
I don't have anything else, Professor. Nothing further, Your Honor. Maybe we should take the lunch break early. I confer with next up.
You're saying you would prefer to take a break before you finish?
Well, we can confer and maybe avoid any duplicative questions.
Sounds reasonable.
Yeah.
Um,
Uh,
So you think you're
If I've
finished?
forgotten some of.
Right. And that'll suit you, Ms. Evans.
Yes, that's fine. I think, as I said, the other day, I'll probably have 45 minutes. So if you want to
All
take
right.
lunch break now.
That's fine. That is fine. I don't have, I don't, I'm gonna have much of a reexamination.
So there's no reason to cut, excuse me, to cut the lunch break short if we don't need to, but perhaps council, you can let me know if we have some hard deadlines, as you say, or some aspirations
I think
to get on planes.
none from us in terms of
No,
flights tonight.
Okay.
We were here all weekend and we're not going anywhere until this segment is done. I understand you have the professor needs to get away tomorrow. I hope the weather, that will be easily done. I hope, and I do thank you very much. It's been a pleasure engaging with you. So thank you.
Okay, so why don't we say 1:30? It's about, I have 1:10 by my watch. Is that enough?
Yes.
All right, so and at that time, Mr. Marcelli will come back and say, and let me know whether you have anything further.
Yeah, I'll either say I forgot to ask this, which I don't think, or we'll just go to Canada.
Okay,
Thank you.
thank you. So just to say, so we're off the record. So I just wanted to.
This court is now resumed. You may be seated.
Good afternoon.
Good afternoon.
Should I presume then, Mr. Marcello, you've finished your cross? Thank you.
Professor Stiglitz, I'm Glynis Evans. I'm counsel for Canada.
Yes,
I want to start with what I hope will be a fairly simple correction to your earlier evidence. I think I've discussed this with my friends on all sides, and I think that there was an error in, you misspoke at a certain part of your testimony earlier this morning. You told us in chief and in your slide presentation that there were enough resource revenues to fund an annuity of more than $6,000 per year in perpetuity. But earlier this morning, you said in evidence, you said there would be enough to fund an annuity of $6 per person in perpetuity. Was that
oh,
an
no,
error?
it was my original one that I was.
Right,
Right, thank
good.
you,
Just to make
thank
sure
you.
we're all clear on that.
Yeah.
That was at about 11:33 of the transcript when you
Yeah,
mentioned the
no, no,
$6. I just
I'm
want to
sorry.
clear that up.
Sorry.
Great. Okay, my colleague, Ms. McNamara, will be putting some documents up on the screen as we talk about them. The first thing I want to ask you about is spectrum. So in your report, you say at paragraph 138, spectrum rights are tied to ownership of the land because the use of the spectrum rights requires one to build towers for the spectrum. And you say in the following paragraph that the value of spectrum is not just that people living in the area can have access to Wi-Fi and mobile phone service, but that people transiting through the area, like those of us from out of town here at the trial, can also have mobile phone service while in the territory. Is that right?
That's right.
Right. So the value of spectrum is that people can use communication systems,
That's right.
and they pay their cell phone service providers for the use of the system.
That's right.
And cell phone service providers pay the federal government license fees for the opportunity to serve those customers.
That's right.
So I want to discuss the relationship to land. You say the link to land is that towers are built on the land.
That's what I said there. There's actually a broader way of putting it that I think we probably should have put in, which is spectrum is related to countries auction the spectrum in their country. So in that sense, Canada has conducts a spectrum auction over Canada because that's the territory that is part of Canada.
But spectrum, of course, doesn't pay any attention to political boundaries or geographic boundaries. Spectrum just exists in the air. It's only the way that it's regulated that governments say, we're going to regulate who can provide service in these areas, who can use the spectrum in these areas.
Well, it's not, it's a scarcity. There's a scarcity of, if you didn't have property law, on land, you would have a problem in land as well. There is a scarce resource called spectrum. The regulatory framework is the way we manage that scarce resource.
Right.
And, unlike normal land, as you say, it doesn't stop. The electromagnetic waves don't say, oh, here is a national boundary.
Right.
But still, each country conducts its auction, and then there are ways in which across boundaries, they negotiate how they're going to handle the problems.
Right. So getting back to the relationship to land and the fact you say that the relationship is that towers are built on the land. That doesn't make the small parcel of land on which a particular tower is built worth millions of dollars simply because a communications tower is placed on it. Isn't
That's
that
right.
So if I had a piece of land in the territory, I could rent it to somebody for a billboard to advertise their local restaurant, or I could rent it to somebody for a cell phone tower.
That's right.
And whether I rent it for a billboard or a cell phone tower, I'm not going to get millions of dollars more because I happen to rent it for a cell phone tower. Isn't that right?
But that's why I said before, the real value of the spectrum isn't the particular piece of land associated with a particular tower. It's with the fact that there is a territory over which the use of the spectrum has value, and that's the way we regulate, the way we manage spectrum. And the right to have a telephone tower, a certain number of telephone towers somewhere, is what gives value. So you couldn't have the spectrum value realized without having telephone towers somewhere in the
But
territory.
that doesn't make the land itself. Let's say you can auction the spectrum. And you told us earlier that the value of spectrum is the ability, is the customer base. You're serving customers. Where you get the money is your ability to charge customers for the service. And the only link to the land is that's where you place your cell phone towers.
No, that's what I was saying. It's not the only link, and that's why, you know, the reason why Canada gets so much revenue from the sale of spectrum, or the United States, is that the spectrum within Canada has a value within Canada, and there's scarcity value. And once you have scarcity value associated with the land, with a territory, let me put it like that, not with a piece of land, but with the territory, you have the ability, you have a rent, and therefore the ability to capture that rent.
So again, linking it to the land. So in my example before where I said, if you just rent your land out to a cell phone service provider, you're not going to get millions of dollars more than what you would get if you rented it to a billboard, because in a market with competition, you know, the competition is going to balance it out. So it doesn't really matter whether you're renting to a billboard or whether you're renting to a cell phone tower, ultimately in terms of the value of that particular piece of land.
Of that particular piece of land, but
Thank
having
you.
some spectrum towers somewhere in the territory does matter.
And the land that we're talking about where a cell phone tower is located is land that will either be rented or purchased by the cell phone service provider.
That's right.
And so that land, that sale of land, for example, if they purchased it from a private landowner or from the province of Ontario, the sale of that particular piece of land is already captured in Mr. Hutchings' analysis of net revenues from the land.
No, it's the right for someone in the territory to have a tower that we're concerned with, not a particular piece of land. So if the regulatory structure, I don't want to put it on the regulatory structure, but if you have the right to control the spectrum over a territory, that is associated with, to manage that, you will need towers. And saying you can construct those towers that will enable the development of the spectrum gives rents associated with the telephone towers. So a particular piece of land isn't particularly important. It could go here or it could go there. You're right about that. But the right to construct one has value, and that's what you capture in the spectrum auction. And that's what we included in our analysis. It's the value of the spectrum auction that we were talking about.
So it's not really linked to the land then, it's really linked to the spectrum in the airwaves.
Well, the land, explain to the territory. That's why I use the word territory. Yeah, it's, it's not the land itself, but the land is the way you manifest it. If you have to have a tower on the land, but it's not the particular piece of land. It's having towers within the territory that allow you to somewhere in the territory that allow you to exploit the value of the spectrum.
Okay, I want to move on to share. You told us that you compared the $10 that you understood Indigenous groups in other areas of Ontario received as annuities. You compared that $10 with $1.60 that the Robinson Superior First Nations received.
That's right.
And I know you told us earlier that that $10 is really actually irrelevant. It's really an arbitrary number. It's best looked at as a minimum.
That's right.
But you also did use it as the basis for your 84% analysis.
That's right.
And when you spoke about the Robinson Superior First Nations receiving $1.60, Justice Hennessy noted it was not just $1.60, but also a promise that that amount would be augmented if the land became sufficiently productive.
That's right.
So the annuities that were promised and paid were paid in this case to the full population of the bands of those people who came to collect their annuities in any one year. That $1.60 and that promise was made to the growing population. Is that your understanding?
I think the amount was paid this was part of the discussion we had earlier today. I think it was a fixed amount. It didn't go up with the population. I could be wrong, but my memory was it was $2,000. And the way we got 160 was dividing that by the population, and that came out to 160.
Okay, so the treaty was not just for $1.60. It was for $1.60 per person at the time, or the amount that turned out to work out to $1.60. And it was for a promise to augment that. And assume along with me that it was for a promise to pay those annuities to every member of the band in perpetuity. Because I think, in fact, that's what the evidence will show.
Okay, if it's 160, whatever that population, the population could go up, it would be more in 160. If a population would go down, it would go down.
Well, in fact, Professor Stiglitz, your colleague, Mr. Hutchings, had looked at what annuities were actually paid over the years. And in fact, I think you took us to the analysis in your slide deck about what the value of those annuities already paid would have been.
That's right.
So you may not be the right person to ask this, but knowing that you worked with Mr. Hutchings and you saw that he did this work, that work will show you that annuities have been paid just up to $4 per person to every person who comes to collect them. So as the population has increased, the annuities have been paid to that increased population.
Mr. Schacter's on speak.
Just as an objection, I believe the record will show that the amount stayed at 500 pounds until 1875. And it's only at that point that people started getting paid. So it's not fair to put to the witness an inaccuracy.
Sorry, what did you say? The
The
global
500
amount was paid, the
the
500?
pounds, which equals $1.60, stayed the same until 1875, when it was augmented the first time. And the amount that each person got when it was distributed, although it was a collective amount, increased or decreased depending on what the population was. And the point my friend was making is that at some point, and it's not at 1850, but it's at 1875, the Crown started paying every individual, whether they should have or not, but this is what they did. They paid $4 to every individual.
I got it.
And in that sense, it was increasing as population increased and would decrease as population decreased. And so I just thought it was unfair to say to the witness what happened between 1850 and 1875. That's all.
Okay.
Yeah, thank you for clarifying that. Yeah.
Yeah, that's fine. I have no quarrel with what Mr. Schachter said. It is true. Let's say starting in 1875, the annuities were paid $4 per person to any person who, member of the Robinson Superior Treaty bands who came to collect them.
That's right.
So, and we know from the stage 1 decision that there is no cap on the total amount of annuities to be paid under the treaty. It's not capped by the numbers of people. It's not capped at the upper end of the total amount that must be paid by the Crown. Is that how
That's
you
right.
understand it?
Well, there's a cap. It's related to the value, of the without loss. So there was no risk to the Crown because they're only putting out money if they can do so without loss.
Thanks. But there's not a fixed monetary amount as a cap in this
That's
particular
right.
treaty, right? So when you compare this treaty with the treaties where it's your understanding $10 was paid, would your analysis remain the same if those $10 were only paid to people living at the time of the treaty and not to their descendants? Are we still comparing apples to apples? If you've got $10 being paid to a fixed number of people living at the time of the treaty versus, let's say, $1.60 being paid potentially to increasing numbers of population in perpetuity, does that change your analysis?
No, because, the way I thought about it is $10 is a, you can think about this as a guaranteed floor. Let me go back. The standard treaty relationship was that $10. And I use that $10 just as a framework for what was the value of a bottom line estimate of the value. And then asking the Crown says, I'll assume some risk and pay you $2,000. What is the risk value of that? How much of the value of this asset should the Crown get for offering that minimum?
So,
And so really, I was using the $10 as a minimum value of the asset and asking the question, what part of that $10, which is a minimum, would I give away for somebody guaranteeing me 160?
so can I ask, is it appropriate to refer to the $10 as the buy outright price of the land?
No, I wouldn't use that term. I would just say it's my estimate of the minimum value from which I could calculate the maximum value of what the Crown should get.
So $10 is not the buy outright price of the
No,
land.
it just it was the minimum value of the asset, the minimum value of what they brought to the table. And that's the denominator. And 160 is the maximum value of the what they were given upfront as a payment. And if the real risk is zero, then the amount they ought to get is much smaller than that 16%.
So again, going back to the comparison, because I had understood in your report that, and perhaps it was actually Mr. Hutchings' report, that $10 was considered the buy outright price. That would be to buy the land. And if the treaties that paid $10 per person were capped at a maximum of, say, 450 pounds, never to go above that, does that really mean that the value of the land is $10 per person, that's the buy outright price?
Well, I use that $10 just as a reference. What I said is the real point was, what was the value of the land? And we did our own calculation of the value of the land, and it was substantially higher than $10.
So why do you come up with 84% then? If you're telling me that the $10 analogy, and it's based on the $10 analogy that you come up with the idea that $1.60 is only 16%, right?
Yeah.
So you're now telling me $10 is irrelevant.
No, what I'm telling you, it's a minimum number, and the risk is a maximum number. And so I was trying to be conservative. So the maximum that you would give the Crown in return for absorbing that risk of $1.60 is 16%. That was really the maximum that I was saying. And so the real number is greater on the denominator than 10, and the real number in the numerator is smaller. And I was trying to be conservative and come up with a number that I hope everybody would agree with is a conservative estimate if you buy into the joint venture model.
Okay, I want to move to investment strategy.
Okay.
You told us that since the Robinson Superior Treaty First Nations have a very long-term perspective, cyclical fluctuations in the market are of little concern.
That's
Is that
right.
right?
I did say that.
And you told us since the bands never retire, they're like pension plans.
Well, individuals retire, but the band goes on, hopefully.
So the band is a long horizon entity.
That's right.
Now, are there other features of the bands that make them a long horizon entity aside from the fact that they don't retire? What makes them long horizon entities?
Well, they're like a nation. Nations think of themselves as going on forever. And so, I mean, that was at least in my mind. You think of yourself like a nation, and a nation doesn't say, oh, we're a 200-year enterprise. We are a perpetuity. We
Okay.
are going on forever. That doesn't always happen that way, but that's the way you ought to think about it.
So in analogizing the bands to a pension plan, for example, with this long horizon outlook, you told us that the bands don't need the same liquidity as an ordinary family. Is that
That's right.
And they don't go through things like unemployment, illness, and divorce.
The members of the band do, but so and those are correlated, but the band itself is longer term and is a collective. So there's a difference between collective risk and individual risk.
Okay.
That's really what I was emphasizing.
So I think we're going to try the joint book of documents online for the first time. One of the productions that we see in all of the experts' reports are the population figures that Canada produced based on records maintained in the Indian Affairs Annual Reports and the Indian Register. Canada produced information about population figures. And that appears in the joint book of documents in a number of exhibits, but we'll refer to the one that appears in your own report. So it's Exhibit 1, tab 0083. And what this is an Excel spreadsheet showing the populations of, as recorded by Canada, of the various bands in the Robinson Superior Treaty over time. And because I think that this Excel spreadsheet is a little bit hard to read, my colleague has it up on the screen, but you can only see it bits at a time. I've actually cut and pasted the Excel spreadsheet and put it into a Word document that's easier to read. So I thought I'd hand that out. There's
How's the font?
better, better than, can I?
Please pass it up. Go ahead. Thank you. Oh, it's great.
Now, there are, yes, it is, it's tab 0083 of the Joint Book of Documents, which came from the Stiglitz and Hutchings binder within the Joint Book of Documents. So in order to convert this to a more readable word chart, I made a couple of changes. One was in the Excel, you'll see there's columns at the end, various places and Chippewas of Lake Superior. So early on, the data, and you can see it, why it's all blank on the first page. Early on, the data was recorded as Chippewas of Lake Superior. So you see the total there, 1872, 1,312 people. No.
Mr. Council, can you repeat that? I don't have the.
The total population, and I have my friend, Ms. McNamara scroll to the top of the document. The total population in 1872 is recorded as 1,312. It's on the screen now.
Okay, that's first line.
Yeah, And what I'm explaining now is if you go to the end of that Excel spreadsheet, you'll see that that figure comes from to the right end. We're starting in 1872 and we're going to the. There we go. Scroll up to 1872. There we go. We're seeing Chippewas of Lake Superior. So you can see in the first number of years, the population was recorded in a lump sum, not per band, but in a
Mhm.
lump sum. You see?
Mhm.
So
And I don't have that column. on
that's
this.
because I couldn't fit everything on neatly. And so I thought the last two columns, the various places, the Chippewas Lake Superior don't really matter because they're included in the total.
Okay.
The point I'm using this chart for is to illustrate the populations of specific bands. So you can see, for example, the populations of different bands, like in 1884, the largest band, for example, was what was then called the Lake Nipigon Band, AZA, 426 people, for example. But it ranges, the populations range from 54 people to 400 people. So I thought, let's take a look at a couple of years in particular. The ones I was looking at is 1929. And here we only have populations every 5 years because the census was only done every 5 years during that time period. So let's look, for example, in 1929. You see the populations of the bands vary. Now, part of this is because over time, new bands were recognized. So some of these columns, you'll see that there was no population and all of a sudden there is, because new bands or bands, I shouldn't say new bands that potentially existed but hadn't been recognized by the Crown were later recognized. So in any event, we start to see
Or
most.
could we say additional bands were recognized? Like there was recognition of additional bands?
I would rather defer to potentially Professor Dribbin or someone who will be testifying about the proper way to describe that. But
Thank
for
you.
the purposes of the population chart records what is recorded in the Indian Register or the Indian Affairs annual reports. And this is the way that it was counted.
So the distribution of population changed.
Yes, that's right.
among other things.
The
Okay.
distribution of population changed as bands, for example, people used to be lumped together in Chippewas of Lake Superior, and then eventually they were understood to be represented by different bands. But the point really that I'm getting at here is just using, for example, in 1929, we see some of these bands, the populations vary from a low of 33 people to a high of 280 people. And then you see the next year for which we have data in 1934, the populations vary from 28 people to 337 people. So my question is, would a population of 33 people or even 280 people, many of whom are children, might they be considered closer to a large family than a pension fund?
When I approached the question, I didn't ask the question of how the funds were going to be managed. I just approached it as a collective and for the First Nations in the RST. And so that particular issue of what happens if you have small subgroups and how you allocate it was not a question that I addressed.
So if you had been aware of or had looked at the actual population sizes of these various nations, would you agree that these groups of individuals, as I said, many of them children, that average 200-300 people, that's a group of individuals that would have experienced the vagaries of life, like illness and unemployment and family breakdown, very directly?
Well, a family would, but what I would hope with the notions of kingship and reciprocity, they would manage it a collective as a whole and be attuned to the variations in the circumstances of particular families. And so for the collective as a whole, they would be able to manage this as a long-term investor, and they would all be better off recognizing that kind of relationship.
And as a collective, as a whole, these groups of 300-400 people, would they not have wanted and in fact needed to spend some of their money, including on goods and services for people who were going through things like illness and family breakdown?
Oh, the fund would generate revenues. The question is, the question is, when you put the money in the 60-40 account that we hypothesized, or even better, invested in the real way that I talked about in health, education, infrastructure, businesses, they would be better off no matter what happened, because over the long term, they would be, the wealth would have increased so much that they would be better off. And that would include taking out money, having, the bond, the 60-40 has enough money in the bonds that they wouldn't have to dip into the equities in the fluctuations, but it would generate enough liquidity in any particular year that they wouldn't have to dip into the principal except in extreme circumstances.
But they would potentially then dip into the interest, and that would be money that could not then be compounded continually at your 60-40 rate of return.
But they could then make it up in the next year. It's sort of like a loan to themselves for a short period of time if they had to. But they didn't have that money. And so we're asking the question, if this goes back to the question on consumption that we talked about yesterday, if they had that money and they had invested that, where would that be today? And they invested it in the 60-40. We talked about that. It would be even more if they had invested in real terms in health, education, or infrastructure. And we talked about the appropriate way to treat consumption if they had to do that consumption, but they didn't have that choice. So the question today is, given that there was that money that was due, how do we think about that
So
today
if
as
they
the
had
opportunity
been,
cost?
if they had been given a choice, then presumably they would have spent some of their money. They wouldn't have just kept it in these accounts being managed in the UK or the US to be continually accruing
But they had a
compound
choice.
interest. They would have actually spent some of the money. If they
Yes,
had
but they
choice.
would have invested in infrastructure and education and health, and they would be even that much better that they would have been on their 60-40. And so I think probably the number would be larger than the number that would have emerged from our 60-40 analysis.
Okay.
Do you mind if I jump in on that question? So when, in your examples and analysis, when you say, had they put their money in a 60-40 portfolio, they would have realized this. And then you gave examples of investment in infrastructure, health, and education, which is partly, I believe, what Ms. Evans is getting at. Wouldn't they have spent their money? When you use the word investment, you cover both of those things. Some in the 60-40, some in the infrastructure, health, education.
Yeah, and the word investment, unfortunately, in economics is used in two ways: portfolio investment and real investment.
Okay.
And what we're saying, let me put it another way, and I think I may have said this yesterday, that if they had been given the opportunity of doing the 60-40, and we talk about what they would have had today, if they deviated from that, if they would have deviated from that, that would have meant it was even more valuable than the amount that we're talking about. I use that word
Yes.
money metric. What was the equivalent of that? And that would say if they had deviated from that hypothetical 60-40, the value to them would have been even greater, whether it was expenditures for consumption to survive or expenditures for health and education. It would have meant in terms of their welfare, it would have been even more important. So that's what I had in mind. It was sort of a benchmark, and I think a conservative benchmark.
I hope I haven't thrown you off
No.
course. I was just
That's fine,
making
thank
sure I
you.
understood the word, the use of the word.
So the stage one judgment found that the annuities owed are both collective and distributive. That is, a portion of the annuities in every year that are paid to the collective should be distributed to individuals. Do you
That's
understand
right.
that? So do you suggest that individuals would not have spent their individual distributions in any year, but instead would have found an investment advisor who would invest everything for them in stocks and bonds in the UK or America?
No, what I was saying is, this is sort of a reference point. We talked about that yesterday. What I said was that how they actually spent the money in the past is really of not that much relevance, because that speaks to the way they spent it, given the poverty that they were in, given that there weren't these distributions. But if there had been the distributions, they would have spent it differently. And what we're talking about today is, okay, you haven't, the money that we described, the amount of money, whatever that number is, that should have been shared each year. And how do you bring that up today in terms of what is the opportunity, what they could have done? And what we're saying is that they deviated from that conservative estimate. It's because it's even more valuable than that amount. We're not talking about what they would have had. That's a hypothetical.
Right. So, but you did say in your report that the Anishinaabe would have invested it over a long-term horizon had they been advised by a planner. So I want to get to this issue about had they been advised by a planner. And my question is, would a group of roughly a couple hundred people, including children, living in remote communities, hours north and west of here, by car, if you even had a car back then, would they have had easy access to educated financial planners with ready access to equity markets in, say, the 1860s or the 1920s?
I think if they had been given the amounts of money that we're talking about, there would have been investment advisors, and somebody would have come forward and say, let's put all these groups together. What is a mutual fund? I can't manage my own fund money, and nor can somebody else. So what do? We have a mutual fund, and the mutual fund manages it for all of us. So here, I hope that there would be enough understanding among the different bands that they would understand it would be worth the while, given that they have this amount of money, to look around and find out who are good advisors and say, let's pool our money together and let it grow. You
And
can't
so-
hypothesize, if I have $5, of course, I'm not going to have an investment advisor for $5. But if I have the amounts of money that we're talking about here, then that becomes relevant.
So another question then is, and here we're talking, if you were to, as you said, if all these disparate groups of individuals living in different bands across a vast territory were to get together and pool their money, and we're talking, back to the chart of population, in 1929, we're talking about 1,600 people. Let's say they were all to get together from their disparate locations across the territory and come together and say, let's invest our money. Let's find somebody in the United States to invest this for us in equities.
Or Toronto.
I mentioned the UK and the US because you told my friend earlier that that's where the equity markets were in the early years.
Yeah. Okay.
So would those people realistically have been confident enough to have left all of their money with educated financial planners in another city, especially when the evidence will show in the 1930s that 75% of that money would have been lost in the Great Depression? Would that group of individuals realistically have had the confidence to just wait it out?
Let me make 2 points. One is, if they had started if they had been given the money starting earlier and let that build up, yeah, the answer is yes, they would have confidence. I mean, the 1929 crash was a big thing. And if they started right before that, no, they would have lost that confidence. But the second point I guess I would make is if they had just done what I talked about, the 60-40, or the even better, the pension, what the Canadian Pension Fund does in the last 10 years, the last 40 years, when markets are well developed, then you get a number that is actually substantially higher than the bond rate. And so, you know, if you really believe that they couldn't have done that, which is a judgment call you have to make, if you really believe they could not have done the 60-40 in the beginning years, which I don't see why they couldn't have, but if you really believe they couldn't have, if you just did it since 1960, and if you actually use the pension rates, the returns on the pension funds, you get numbers that are not that different from the numbers that are substantially above the 5% rate.
So let's talk about rates of return. You told us yesterday that the nominal rate of return doesn't account for inflation, and that since inflation has averaged 2 to 3% over this time period, to get to the real rate of return, you need to subtract 2 to 3%.
That's right.
So in effect, you told us yesterday, the 7.2% rate of return for the 60-40 portfolio would be reduced by 2 to 3%. And the 5.3% band trust account rate would similarly be reduced by 2 to 3% to convert those into real rates.
That's right.
So, for example, if we take your 7.2% rate of return on the mixed portfolio, and if we estimate inflation to be 3%, then we could express the real rate of return at 4.2.
That's right.
And if I understand correctly, the proper calculation is actually to multiply by the rate of inflation. But for simplicity, we're making it like a deduction. Is that right?
I was doing what we call continuous time, and so that if you do it in discrete time, it comes out a little different. But if you do it, so that's a technical.
It's a technical point.
Issue.
Good. Okay. So you were asked about the 8.2% rate of return that Professors Booth and Kersner use for business investment. And you told Mr. Schachter that the 8.2% is the real rate of return that has already taken into account inflation.
That was my understanding. Yeah.
Right. So that is the rate that Professors Booth and Kersner are using for business, is 8.2, and that is a real rate of return that would then be comparable to the 4.2% that we've just talked about being your the 7.2. Once you count for inflation, it would be a 4.2. So we're looking at their 8.2 is comparable to your 4.2 because they're both real rates of return.
Yeah, but mine already has the depreciation.
Yes. Thank you. So we're leaving depreciation till the end, but absent the depreciation
But that's a big
factor,
thing.
Yeah. I just want to make sure we're both talking about real rates.
Okay.
So I want to take a look at Professors Booth and Kersner's report. My colleague has it up on the screen. We're looking at paragraph 98 of their initial report. And here they explain how they calculated the nominal annual rates of return. And I'm going to skip to B because that's the business one we're talking about. So to calculate the nominal return, they take the annual rate of return for business spending, which is a real rate of 88.2%. That when you express it mathematically in the formula, you express it as 1.082, but that means 8.2% is the real rate. Is that right?
Yes.
And then you see in their calculation, they then multiply that by the inflation rate for the year.
I see what they've done there.
Yes.
Yeah.
So then they end up getting a higher number than 8.2%. Is that right?
Yeah, the nominal rate is going to be higher than the real rate.
Right. And then they account for depreciation. And in the equation, we see this expressed as times 0.95. And if you go down to the footnote, you'll understand that 0.95 is actually how you express the depreciation factor of 5%. It assumes a 20-year life for the business investment, and that works out to that you need to take your nominal rate of return and effectively multiply it by 0.95, which then decreases the rate.
That's right.
Right. So we're looking at the real rate was 8.2. They adjust it to the nominal rate by including inflation. Let's say inflation is 3%. That's the number we were using earlier. So really they're taking the rate, the nominal rate of 11.2%. Then they deduct depreciation from that.
Okay, and, okay.
Is this new to you?
No, I always do things in continuous time, and that means these things don't, when you have an exponential, you put the rate, the real rate minus the inflation, plus the inflation rate minus the depreciation rate, and it's just a straight arithmetic.
So
So
have
it's
you,
not the one pluses.
so
But
have you not looked at this calculation before?
yeah, I have, but it always, the numbers turn out not to be that different.
Okay, so I want to go back then to your chart, your table 3 on page 60 of your reply report. And I think you might have used that same table in your slide presentation, but my colleague has brought it up on the screen. This is from your report, again, table 3, where you're showing Booth and Kersner's real return at 8.2, and then you say they take the 5% depreciation rate, and you told us yesterday that this means that really they're only using a 3.2% rate to bring forward business. That's what you told us
So,
yesterday.
I mean, the way to think about this, what does it mean? You have a machine, to go back to this machine, you have a machine that is at the end of the year gives you an extra $8, $100, it gives it an extra $8.20. But at the end of the year, 5% of that machine has disappeared. It's worn out. So now you don't have a full machine, you have a fraction of a machine. And you don't have to go up and down. The fact is, one is the real return. You add the extra return, and then you subtract the fraction of the return that has disappeared.
The
So
point,
that's why economists, when they look at this, you take the real return and you subtract the depreciation rate.
but in
that's what-
fact, the point I'm trying to make here is that in yesterday's testimony, it's really skipping a step to say you take the 5% off the 8.2, because in fact, when you look at Professors Booth and Kersner's calculation, first they adjust for inflation. So you're actually taking the 5% off the 11.2%.
No. The way you should think about it, what does the depreciation mean? It's the fraction of the machine that has disappeared. It's really very, very simple. That's the fraction of the machine. If that's your estimate of the depreciation, you know, if 5% of the machine disappears, you have to compensate the gross returns that you got for the fact that you had a machine that was worth 100. 5% of that machine is disappearing. You now have a machine that's worth 95. It just disappeared.
Yeah.
And then you add to that the extra product that you get, and that product is 8.2. So you take the 8.2, you subtract out the fact that you thought you had 100, and now 5 of that has disappeared in the machine disappearing, and that's 3.2.
So let's talk about depreciation, since you've
And,
raised that
oh.
depreciation issue.
Okay, can I make one more comment to help? In my mind, and I said this yesterday, it's much easier if you always think about things in real terms. And rather than increase in money and then take money away, just think about these as machines. A fraction of the machine disappears. The machine gives you a real return. What does that mean? Gives you real goods that correspond to the units in which you originally measure things. So if you just stick with the real, it gives you a much better feeling for what is going on.
But you yourself use nominal rates in your report.
No,
7.2
when
is
I
a
was-
nominal rate.
No, but when I was analyzing this particular set of numbers, I was focusing on reals, and he begins with real, that's 8.2. Depreciation is a real number. What fraction of the machine disappeared? You have a 20-year machine, 5% of it disappears every year. And so that's real. And so I was taking the 8.2 real minus the 5 real to get 3.2 real.
But when you look at Professors Booth and Kersner's actual results, they're adding in inflation. We've seen in their calculation, they multiply that real rate of return by inflation.
Yeah, I mean, but that doesn't change the reality of the number. If they're talking about an 8.2% real return, and they're talking about they believe you should subtract off a real depreciation, 20 years. They mentioned 20 years, that's 5%. That gives you the number that I talked about.
So then I did want to move to depreciation. And I wanted to go back to the example that you gave us about money spent on education for an individual. You said that eventually the individual dies. So you told us in your testimony that, while there's a stream of positives during the person's lifetime, eventually that person dies and the return gets down to zero.
That's right.
So in Professors Booth and Kersner's approach, they use a declining balance approach to depreciation.
Yes.
So, for example, money spent on a pair of glasses that are no longer useful because the lenses are smashed, they still bring that forward at their human capital rate of return. It's just by using the declining balance approach, they're bringing it forward at a very low rate of return over time. Is that right?
Well, I mean, that's not the way I would approach it. That's maybe a way accountants do it, but what I was trying to focus on, what was really going on, and that my examples were trying to illustrate how you really ought to do it. And I thought my example, I hope, brought it out clearly that if you're going to use that, I did the glasses are going to wear out, whatever your money machine is going to wear out, and you're going to deduct depreciation, you begin with the gross returns and then you subtract depreciation. But if you do it the way I did in my money making machine first, where you looked at the net returns, then you don't deduct depreciation, no matter what particular accounting approach you take.
So that I understand correctly, to compare the two approaches, Professors Booth and Kersner say that if you have this pair of glasses that ends up getting smashed and is no longer useful, Professors Booth and Kersner say that it has a diminishing amount of rate of return over time because it's no longer useful. This is their depreciation point of view. But if I understand your approach correctly, what you would do is say that pair of glasses continues to be reinvested at 7.2% over and over and over again in perpetuity, because you never actually spend any of the money. You just keep putting it into stocks and bonds.
No, I don't think that's the way I understood what I did. What I said is each of these projects is a separate project. One way of thinking it. You have your glasses, it gives you a return of being able to see for 5 years. And you can calculate the cost of the glasses, then the gross return, and it has a gross value, and then it stops after 5 years because you no longer can see. And you either calculate the gross return, the 30, 30, 30, 30, that's the 30% return. And then you can depreciate, you would take into account that the glasses last 5 years. So then I take that 30% minus the 20% depreciation, and that gets me 10%. Or what you do is you take the total returns, subtract out the cost. That gives me my net return, which was 50 divided by 5 years, 10. The net return is 10%. And then I don't take out depreciation.
So,
So you do it either way. Those are two different ways of dealing with the problem. But what you don't do is take the net returns and then depreciate.
but in your model, you're not depreciating at all because every bit of money that should have been spent to the Anishinaabe just sits in the mixed portfolio, continually accumulating compound interest in your model.
What I'm saying is that project yielded a 10% of return. And then you have another project yielding another 10% return. And each project dies and you start a new project. And so you compound at 10%. We've taken an account of the fact that that machine dies, pair of spectacles last for 5 years. We've taken account of that in our calculation of net returns.
So going back to the education example, you noted that spending money on an individual's education has a societal benefit. It benefits society, and that benefit, you said, could be as much as 15% is the rate you gave us yesterday.
I think a lot of those estimates are the private returns to education, not that go beyond the social return. I mean, the social returns go beyond the private returns. Those are the returns to education that individuals appropriate.
When Justice Hennessy asked you about the difference between the individual versus the collective, you spoke about that there was a societal benefit, and maybe it's the 15%. I think if we scroll through the transcript, we'll see that the court. So the court asked about the rate of return, and you said most of this is the social return to education. So you're looking at social costs and social return.
Yeah, I'm sorry, I didn't make that clear, and thank you for clarifying that. So if we were talking about social benefits, there are a lot of social benefits that go beyond the private benefits. For instance, having a well-educated society,
Yes.
An educated citizenry, that none of that is included in the calculations that were cited in the studies that we cited.
So
these are narrow economic benefits
So-
that don't incorporate those.
you're really talking about, are you talking just then about benefits to individuals, or are you talking about benefits to society?
No, well, those economic benefits, we think of it as part of the societal benefits, but they're not all the societal
Right.
benefits. So we're not including the broader range of societal benefits that arise out of having
Right.
a well-educated citizenry.
And what I was going to ask you is, these rates of return, might they be different if the educated individual then leaves the community and goes and settles somewhere like Toronto rather than the Robinson Superior Territory? Are you losing some of that societal benefit in education?
If that happens, it's a phenomenon called brain drain. And so you might lose some of those, but that's not germane to the particular issue that I was addressing. What are the particular numbers being used in that study and what they're referring to? And none of the studies we were talking about adjust for brain drain.
Okay, yeah, so it may not be relevant to your position on what the appropriate rate of return is, but the point that I'm making or asking your opinion on is, isn't it the case that there will be a number of factors that are going to influence what the actual rate of return is going to be? For example, education, the actual the actual rate of return in real life is going to depend on things like, did the individual actually come back to the community?
Yes, I mean, there are factors that would increase it from that number and decrease it. So brain drain would decrease it. The fact that we haven't captured all the societal benefits that I talked about in the beginning would increase that number. But, you know, if you have to begin your data analysis somewhere, and you look to the literature, and what does the literature say about what is the economic return?
Right.
And that is the kind of numbers, 14%, that were substantially higher than the numbers referred to in that study.
And that leads me into the next question that I wanted to ask, which is about these other factors besides just the monetary factors that you have to take into consideration. You talked about different kinds of consideration that go into how people value trees, for example. It's not just how much money can you make off of them, but it's how beautiful are they and what is their spiritual importance to you, for
That's right.
example. So it's difficult to capture the economic value of these kinds of considerations in monetary terms.
That's right.
And when parties make deals or agreements, they may have considerations in mind that are a lot more than just how much money can I make.
That's right.
So in the context of the treaty here, one such consideration for both the Anishinaabe and the Crown might have been invasion by other actors. So their partnership might not have been only for the purpose of making both better off economically. Would you agree?
That could be. Yeah, yes.
Thank you. I think those are all of my questions. Thank you very much, Professor Stiglitz.
Thank you. I'll ask Mr. Schachter if he has any questions.
I have no questions in redirect.
Wow. And Mr. Gover.
I have no questions. Thank you very much.
Now, while you're on the stand, Professor Stiglitz, I'm going to ask you the question that possibly you have been asked by your counsel, and that is with respect to your copyright in your report. And this comes to me today because I've had a first request for access to exhibits. And on the form, there is a question about the scope of access. And the scope includes viewing it. I forget what the intermediate one is. And the greatest scope is publishing or disseminating it. And in stage one, we had all expert witnesses waive copyright so that the work could go out into the academic field. Either Mr. Schachter, have you checked with that before? It was my understanding it was the goal.
You know what,
yours.
I is an issue I have to talk about.
All right, so I'm putting you on the spot.
Oh, in general, my view is transparency is very important. Public dissemination is very important. The issues that we've talked about, I think, are very important. And so I'm perfectly happy to have them as widely disseminated.
Thank you. So I will answer that particular request for access to Dr. Stiglitz's reports that have been filed as exhibits. That's how the request was framed, as the exhibits. And we can talk about this later if we need to for any others. Thank you very much, sir. I hope that the weather cooperates with your travel plans. And I appreciate the time you've given to the court.
Thank you.
All right, so is there anything we need to do today other than
I
break till Monday?
believe we're recessed until Monday next, and Mr. Hutchings would be the next witness on Monday.
All right, and
And in the meantime, we're endeavoring, all council to work up a new schedule that we hope to be able to deliver to you within the next day or so.
And I think that schedule should be tentative and we might convene by phone or something to take a look if there are any significant changes. Do your best and then bring me in.
Okay, thank you.
All right.
Would it be best to organize a call now, perhaps for Friday, or would you like to do that
That's a
off
great idea.
the record? Because I also see some utility in having a brief call just to discuss particularly some of the lengths of time that have been allocated to particular experts.
Okay. Is that possible, council? I'm getting a yes, nod. Yes. Okay.
I would be happy to circulate a Zoom link for 10 o'clock on Friday.
10 a.m. Friday. We're getting a lot of yeses. Okay,
Okay.
that would be very helpful. Thank you all. All right, thank you again, sir. We'll break.
Oh yay, oh yay, oh yay. The sittings of this court are now concluded. Long live the king. Thank you.